Let's go through more of the steps. Someone comes into your office. Mm-hmm. Before you file for bankruptcy, you have to assess their assets, try to see a pathway, 7 or 13. Let's just assume 7 or 13. Once they get started, what happens next? How do the rest of the stuff play out?
For us, most of the time it's going to be a 13, just because mostly we work with homeowners. 7 is generally, you want to discharge all your debt, you don't really have any income, you don't really have much assets. We'll take those sometimes, but generally we have to work with homeowners. Depending on, I'll start requesting all the financial documents from you. I'll do like a brief conversation with you first, see what you want to do. Most of the time you're behind on your mortgage. I'll try to find out how long you're behind. If you're not that long behind, I'll do what we call a traditional Chapter 13. Traditional means you're just going to pay back the arrears on the mortgage and other stuff. And, depending on how much you owe, mostly it's going to be 100% plan, but sometimes it's not. But then what me and Peter actually not mostly, but what we often get is someone calling us and telling, I have a sale date in 2 days, I don't know what to do. Or we get referrals from housing counselors who are like other entities that work with homeowners who set them up with us. And it's like, usually if you have a sale in 2 days, I can't do anything for you but I can tell you, you can go file for bankruptcy by yourself if you call me 2 days before. If I collect all your financials and if everything looks right to me, I'll represent you. In terms of financials, we just collect whatever, bank statements, tax returns. You have to file tax returns. A lot of our clients don't file tax returns, and then it's one of the requirements that if you're going to be filing for bankruptcy, unless you're exempt. But if you have to be making way too low, and if you are, you're probably not going to qualify for Chapter 13. We collect all the documents, and then we'll do like a more intense intake with you where we'll try to ask you every question, like, do you have a house in Puerto Rico? So many times, right before we file, we get people, oh yeah, but I forgot to tell you, I have this personal injury lawsuit. I expect to inherit like 100,000 from it. So, okay, to start all over again now. But what we do is we fill out the petition, and parts of the petition are called schedules. Schedule A and B are like your assets. Schedule I and J is like your income and expenses. Basically, we fill out all your income and expenses to a T. And then if you're filing Chapter 13, we also fill out a plan, like who's going to get paid what in the Chapter 13 plan. And if everything's good, we file your petition for you. And then depending, you're going to have something that's called a 341 meeting. The 341 meeting is that meeting with a trustee, what we talked about earlier. Trustee is there to examine, to make sure you didn't lie on anything, to make sure everything looks in place, everything looks correct. Everything depends on like what your petition, the question the trustee is going to ask your client depends on like what you put on the petition and things like that. And then the other, I said traditional Chapter 13 is like where you're going to pay arrears. People who call us right before the house is going to be sold, generally they've been in foreclosure for like 6 or 7 years. So most of the time they don't have the income to pay back the arrears. But bankruptcy court in New York, so it's not every bankruptcy court in every single state. I think only a couple states participate in loss-mit.
And it depends
yeah.
also on the individual court. So like
you can't do on Long Island.
So just clarification about bankruptcy. So bankruptcy court is federal, right? So the great thing about it is on a basic level, it's the same rules in 50 states plus Puerto Rico, because Puerto Rico has its own bankruptcy court that follows the federal law. But the thing is, then you have district courts, so individual districts. So let's say you're in Brooklyn, Queens, and Long Island, Eastern District, and then if it's Manhattan, the Bronx, and like parts of Westchester is Southern District, right? But you have different courts in those districts. So the Eastern District has 2 courts. You have the one in Brooklyn and Queens. All the judges do loss mitigation. But then you have the one in Long Island in which only some of the judges did them, and then now, I haven't practiced out there in a while, but here none of the judges do it now.
So loss mitigation is something like, if you're way too behind on your mortgage, you can't pay the arrears back. But you can apply for something known as loan modification. So it's basically you submit your financial package to the bank is going to review it, and they can see if they're going to modify your loan. This is mostly what we do in state court, but you're allowed to do it in bankruptcy court too. But only few bankruptcy courts participate in the process. And this process was started by Judge Morris in the Southern District of New York in Manhattan as a response to the 2008 financial foreclosure crisis. Because there were so many people behind mortgages, so many people in foreclosure. So she instituted, I guess, I don't know if it's a rule or this program, I would say, she instituted this program called Loss Mitigation Program, where you have another option if you're filing for bankruptcy, where you can engage in loss mitigation with the lender and try to resolve and get a loan modification and basically get a new loan with the same lender if you qualify. If you had a temporary financial hardship, you were out of a job, but now you have a job, you can apply for loan modification. As Peter said, right now, though, all the judges in Brooklyn do it, but none of the judges in Long Island do it. And it's individual judges' preference, I guess. And 2 judges on Long Island used to do it, but they stopped.
And what goes into like the judge? Like if I go into that court, I can't, and I request it, and there's a judge just in another county. Like I can't. What is going to be the justification for that judge saying no, thank you?
I don't participate in it.
Yeah.
Like they just decide not to.
Because they don't want to do it.
Oh wow.
And there's nothing in the bankruptcy court that actually authorizes that program. It's just judges who decided they want to do it, and then to help homeowners who are behind on like mortgages and things like that.
Wow.
Yeah. It's
Damn.
But there are other things you can also do in bankruptcy besides like loss mitigation. Like you do like an adversary proceeding, and then also you can object to claims. And this is actually a really cool thing. So let's say because what happens is when you go into bankruptcy court, it's not like you file and then the credit card company or the bank says, okay, this is you basically just have to state everything that's like owed on the mortgage, right? And the court says, okay, we'll take your word for it. No, what happens is they have to come in and file a proof of claim, right? So you have to, and the proof of claim is basically, let's say a credit card company says, well, you owe me $30,000. They have to come in, they have to provide supporting paperwork, like a payment history, supporting that $30,000. And if they don't do it in a certain amount of time, then that claim is barred. They can't come in, or they have to file a motion to extend the time so they can bring in the claim for whatever reason. But you can actually object to that. I actually had to do that recently with a mortgage. I had to object to the amount, and then basically you file it as a motion, and the judge hears it, and the judge can say, "Yeah, you're right. You say they owe you $50,000, and they can only prove they owe you 20. Yeah, I get it. Okay, I'm going to issue an order. They owe you 20 now." And see, I can be quicker than state court, and then you can also do what's called an adversary proceeding, this is actually a really cool thing about bankruptcy, because you can file the bankruptcy, you have 30 days, you'll file the adversary proceeding. So let's say you say, okay, well, this bank is going to file a proof of claim saying I owe this amount, but no, this is fraud. This is straight up fraud. I'm going to file another lawsuit in bankruptcy court, and we're going to have a trial over it in bankruptcy court to basically get that amount discharged because we say it's fraud. And then you can do like discovery, as in you can exchange, the sides will exchange documents, but it happens a lot quicker than it would in state court. So instead of dealing with it case by case in state court, you can basically bundle everything, throw it in bankruptcy court, and get your entire situation, handled. And that's why you see Chapter 11s, they require so much work. And Chapter 13s as well, because it's not just dealing with like, let's say if you have 5 creditors and 5 cases in state court, you're dealing with all those at one time in bankruptcy court.
Now, when you say state court, you mean like civil court?
Yes, state civil court,
State
yes.
court.
Oh, okay, like small claims court.
Or like depending on it, but generally like Supreme Court, Supreme Civil Court.
Okay, yeah. Okay.